the lawyer for the decedent's family has sued everyone all the way up the chain, including the company that owned the well. And they really actually have not a lot of control over what's going on there. The drilling contractor and the consultants have most of the control over what's happening at that site. They have a company man that's there for consultation about what they do when they run into problems with drilling, but the drilling contractor is the main company that's in charge. And so there's all kinds of questions of who's liable in that situation, who actually has control, what sort of vicarious liability there is, what insurance policies there are, and because, well, I think that in that case they decided that wasn't associated with the well, but the plaintiff's attorney was really trying to pull in everything he possibly can. And where we have the same issue with taxes, and there's differentiation under sales tax law in Wyoming as to what is subject to sales tax and what services are and are not subject to sales tax associated with the well. And that's a hard line to draw. Because he was there because he was drilling the well, but he wasn't actually even on duty. And he was in violation of his employment terms. In fact, I think he might have actually been fired when they weren't letting him leave. Environmental and regulatory litigation. This takes a different route usually because it starts with administrative agencies, and sometimes lawsuits will arise because an environmental group is trying to force an administrative agency to do something, but a lot of times the way this litigation arises is through an agency doing something and it being appealed by either industry or environmental groups. And NEPA is the biggest area for that, and Endangered Species Act. Let's see. Got 5 minutes left, so I'm going to kind of skip over some of these things. Just one quick story. Antitrust is another area that you might not quickly think of, but there was a case that, I think it was in Michigan, I should look at this, where 2 companies were leasing in one area, and one was considering pulling out, and there were some emails from the other company saying, we need to figure out what they're doing, and I think the gist of it was we want to take their lease position or acquire their lease position if they're going to pull out. But what ended up happening is they did pull out, and then the other company, their lease bonus rates plummeted because there was no competition anymore. And there was an allegation there that the 2 of them were communicating and engaging in antitrust prohibited activities. Let's see. So the complexities of litigation, as you've seen, there's highly technical issues from scientific, business, and legal, and there's lots of different parties. Even when you're talking about one stakeholder group, there will be various parties associated within that stakeholder group. And we're highly influenced by politics in this industry. Ethical issues. As I was sitting here before the presentation, one of the big issues that I didn't put on here, I don't know why I didn't think about it. There are a lot of situations, and I've seen this a whole lot in the wind energy industry, where the company will pay for the attorney's fees of the landowner. And so you have to be very careful if you're going to do that. You have to be very careful about how you approach that, because it's almost automatically, I mean, it is automatically complex. And there has to be lots of disclaimers and making sure that the landowner understands the risks of that. Confidentiality is another difficulty as far as having to be very careful not only with attorney-client information, but proprietary information such as the attractiveness of a lease play, a reservoir, or lease bonus rates. And like Max mentioned, those are never in the lease. And dealing with unrepresented parties at the leasing stage, a lot of times landowners are not represented, and there's lots of lawyers who are landmen. And staying up with competency in the area is definitely an ethical consideration. And there's so many issues involved here. You have to be really careful about taking something if you don't feel like you have a good understanding of what's going on. And trust funds, I don't typically take my landowner's payments into my trust fund, but I do handle their checks as far as I hold on to a lease or a check until we kind of act like an escrow agent. Just real quick, and I had two cases I was going to discuss, but the Migratory Bird Act case that was mentioned in the debate the other night, what that was there were 7 companies that were cited. There were 28 dead migratory birds near their reserve pits. 3 of these settled out, and 1 was dismissed, and 3 went to hearing with the district court. This is an example of a reserve pit. This is on a very big well, because that's a very big reserve pit. But this liquid down here is drilling fluid. And it came out of the fluid has to be injected into the wellbore to get the stuff that's in the wellbore out, and to keep the drill lubricated. And there's lots of fluids involved. Bentonite is a big component of some of this, but there's also, in fracking, there's a lot of water involved. It's 98%. Percentages vary, but at least 95% water has to be in. And when that comes back out of the well, they put it into a reserve pit, partly as the definition says, so that they have emergency fluids on hand if they need it, and then also because the solids settle out, and then it's part of treating and disposing of that resource. So some birds died in here, and then died on site because oil does not go well with birds. The Migratory Bird Act, and those of you who are bird hunters are familiar with this because you have to get your federal duck stamp. You cannot kill or take a migratory bird without a permit. And this case involved criminal citations for the companies and the workers at those companies where the ducks died or the birds. The North Dakota District Court found that these criminal charges could be brought because there wasn't any intent, and the statute did not appear to require incidental takings to be criminally prosecuted. That's not always the case, and I'm not proud to say that the 10th Circuit has found differently, and that if they are engaging in an activity where they know that there could be birds flying in, that they have strict liability for dead birds. And a lot of, in a lot of circumstances, drilling pits are required to be netted or flagged, and North Dakota doesn't require it in all circumstances, but it's just, this case is just an example of the various levels of regulation that you have to be cognizant of in the oil and gas industry. And then, just real quick, in Pavilion, I'm sure you've all heard on the news, the EPA is investigating it as a potential Superfund site, but the big controversy right now is whether or not they've actually found anything in their test samples. I have a little history of this here because I was involved in litigation with one landowner against the former operator of that field, which was named Tom Brown. And Tom Brown's assets were sold out to Encana. Encana is, in my opinion, a very responsible company. They've been really proactive. There were a lot of old drilling pits, reserve pits out there like this, not as big a scale, that were not run because they were really old, and that was before we had the regulations for those. So normally nowadays they have to be lined with a heavy plastic liner, and they were not. So there's different areas of potential contamination for that well, or for the waters, the groundwater there, and almost everyone that I talked to is from there, and I have a lot of family that's from that area too, said that water's never been good. But the slides in here, and you can look at them on the, when you get the PowerPoint, just show how hydraulic fracturing is, how it occurs, and then how this schematic is a good example of how it's sealed off, because there's this distance that it goes down before it ever has any fracking. And they're not fracking this stuff is not communicating. It's the producing reservoir that's fracked, and they design these, and it's all very, very highly technical, but to not go outside of the reservoir. And even if it did, there is a capstone layer above it. So when you hear of groundwater contamination, the reason for it is like the Crosby well in Clark, where they lost control of the well, they didn't have control of their drilling fluids and their processes, or there's been a problem with the completion. So they don't have these protective layers put in correctly. And that is very highly regulated. It doesn't happen very often, but it does happen. That is what causes groundwater contamination when it happens. There has not been a recorded incidents or any proven incidents of hydraulic fracturing contaminating the groundwater well or groundwater reservoir. Okay, I'm pretty sure I'm over my time. So if anyone has any questions afterwards, I'll be happy to answer them.
Thanks, Nicole. Great job. Let's take a 15-minute break and come back here in about